going inside the issues of our community. This is Local 12 Newsmakers.
On Monday morning, a small crowd of protesters gathered in front of the Hamilton County Courthouse. They were protesting the decision of the city of Norwood to take about 80 parcels of property by eminent domain and turn them over to a private developer to expand Rookwood Commons. After the protest, the issue was debated inside the court for the rest of the week. Good morning and welcome to Local 12 Newsmakers. Although most property owners in the impacted area have agreed to sell, a few have held out. Local 12 reporter Dennison Keller prepared this report as the trial was beginning last Monday.
Caught in the middle of the protests and court hearings are homeowners like Art Adams.
We were supposed to be out of here in October 2 years ago.
He agreed to sell back then so he and his wife could move into a continuing care facility, one without steps. But now almost every step of his life is in limbo.
The uncertainty is that you can't make any plans. You can't decide that you're going to do this or you're going to do that, especially with my wife's health.
Mary Beth Wilker's life is in limbo too, though she prefers the status quo. She likes the exposure her design business gets across the street from Rookwood Commons. She refuses to sell and can't see why Norwood should be able to make her.
Why is it that the city can take my property and give it to a developer for his own private use and for his own profit?
But Norwood maintains the public also profits, and the city must prove that to keep the court from blocking its eminent domain plans. The city argues the proposed Rookwood exchange would mean $400,000 a year to Norwood schools and $2 million a year in tax revenue for the city.
So a project like this would go a long way to helping them meet the financial difficulties that they're facing right now.
But some say that is still no justification for taking someone's private property.
I think everybody's property could be a potential target with the abuse of eminent domain that's taking place here.
This has been going on for over 2 years now, and I think it's time that this finally be settled one way or another.
To discuss the issues involved, I am joined this morning by Nick Motz, one of the property owners resisting the eminent domain order, and Brad Mank, a professor in the University of Cincinnati College of Law. Professor Mank specializes in property law. Welcome to Newsmakers.
Thanks, Dan.
Nick, just to start out here, what would you say, and I'm sure you've had these conversations, with homeowners like Art Adams, who says he's ready to go, his whole life is on hold, he can't move forward because a few people are resisting?
I've had several conversations with not specifically Art Adams, but people in his situation now, and I think they made a mistake of not having an understanding of what the contract they signed stated. They've all entered into agreements that were open-ended, and in a lot of cases they did not realize they were. They did not seek legal counsel or help.
My understanding is that the offers they have got, in terms of the dollars, they have been offered more than the property was valued at. Is that in other words, from a real estate sales point of view, they're getting good deals?
In their mind they are, and some of these people signed contracts up to 2 years ago, and I question whether that property is still worth what they believe it is worth at this time.
Okay. Let's go over and ask another question about one of the bites in that piece. The attorney, Tim Burke, said Norwood citizens would benefit from the sale of this property and the development of it by Rookwood Commons, by Anderson, because there would be more tax revenue. From a legal point of view, does that really make any difference, though, that the city would benefit?
Yes, it does make some difference, because the justification for eminent domain is for public use and public welfare. The Ohio Constitution talks about benefiting the public welfare and for public use. So there's the argument, if you have a higher tax revenues from the property, that the public at large is benefiting, the city of Norwood at large is benefiting from that. And that's a justification for it.
Now, is eminent domain, you referenced Ohio statutes, is eminent domain and the rules that surround it is that determined by legislation, by positive law that lays out and sets up a framework for how, or is it determined by court decisions?
It's in the Ohio Constitution and also the United States Constitution, and both of them say that you can take property, eminent domain, for public use, and the Ohio Constitution also talks about public welfare. Of course, one of the problems is how do you define public use or public welfare, because they're fairly vague terms, and so the courts really have defined them over the years. So there's some legislation, but primarily it's the courts defining what public use is, what public welfare is, what a blighted area is. So the courts have done that over the years.
One of the things that I think rankles people who own property in that area is this term blighted area. We've seen a little bit of video here. I'm sure all of us have seen stories about this over the past couple of years. I suspect that a lot of us have driven through that neighborhood just because we're interested. It's hard to describe that as what I normally think of as a blighted area. How would you describe the area?
I would say the area is definitely not blighted. The situation here was what I would call a sham of a study that was completed at the expense of the developer to say that the area was blighted, and what's now coming out as we look at that study is it's just filled with errors.
For example?
50 to 75% of that study has errors. For example, they counted negative assessment criteria 2, 3, 4 times in some cases to get the count higher and to make the study look worse.
What, from a legal point of view, is there a legal definition of blighted?
It just depends on the facts of the case. The courts have left that awfully vague, so they've talked about urban renewal and taking blighted areas, and some of the earlier cases were truly slums and getting rid of rat-infested slums, but today you have more of these kind of cases where they're more borderline, more questionable uses of it. So I think it can be stretched beyond what the original intent was, and does raise questions about whether it's fair if the area really isn't that blighted.
When you look around the country and you look at cases that don't involve old decrepit buildings, you involve usable property, you look around the country at different courts, is there just a legitimate vague area here? Have some courts ruled in cases like this in favor of the city and others ruled in favor of property owners?
That's exactly right. The courts have split. Probably the majority of courts have tended to favor the city in terms of using eminent domain, given them the benefit of the doubt. If it's borderline, they've tended to go with the city and said, well, they think it's necessary for development, but it's still very controversial, and many of the court decisions are split with some judges agreeing with the city or state, and some judges going the other way. So there is a big division. It's a controversial issue.
Now, your group is being represented, or the property owners who agree with you, are being represented not by a local attorney, as I understand it, but by a Washington-based Institute for Justice. Is that, have I got this right?
That's correct. We have a local attorney here with Wood and Lamping that is working with our attorneys from D.C., but the Institute for Justice is a nonprofit group of attorneys going around the country and fighting just this abuse of eminent domain.
Did you find them, or did they find you?
We found them. We were actually put in contact with them from a local person here, researched them on the web, used a lot of their materials along the way. They've crafted a kit to help people in our situation, to educate us, tell us how to fight abuses like this, and we've been following that kit.
In Ohio specifically, Brad, have there been other cases that parallel this in your mind in Ohio courts?
Yes, there have been. I guess years ago, the Ohio Supreme Court had a case in Cincinnati which was slums and urban renewal, and they talked about the city could take the land, blighted land, and sell part of it to a private developer. So there's some precedent for that. There was a more recent case in Toledo last year where they took some land. The property owners fought that, and the city was taking it basically to hold the land because Chrysler might develop it into a Jeep factory in the future. So they're really kind of holding it for the future, and that case was decided in favor of the city of Toledo. So there are cases, but it remains controversial because the definition of blighted isn't all that clear.
So the thing here is, it sounds like, although there's certainly a gray area here, the courts have tended to tip in favor of the government entities. If you lose this, and of course we don't know that at this stage, if you lose this, will you then appeal?
Yes,
So this could stretch out much longer,
it could.
leaving people like Art Adams in limbo much longer.
That's correct. I'd also like to point out that people like Art Adams are being held hostage by the developer himself. He has every mean possible right now. He could just outright buy and purchase Art Adams' property if he so wished, but he has not done that.
Is there also, this is about property, and you own a building, your wife runs a business out of it. We saw a little bit, we actually heard her, we saw the property, and it's right across. It's in a very favorable position. This is property, though. Could this just be a financial deal? Does the developer just need to, one, maybe offer you more money, or two, offer you money plus offer office space, favorable office space at favorable rates to your wife's business? Is that what this is really about?
No, we've stated this with the developer, with the city from the get-go, that this is not about money. Everyone in our group are people that, for whatever reason, want to keep their property. That take the Gambles, for instance, just retired. They've lived there for 35 plus years. They love their house the way it is. The last thing they want to do right now is be uprooted and want to move.
How many people have joined your lawsuit?
There's 5 people in our lawsuit.
And you're not a resident there, you're a business owner there.
That's correct.
How many of the people in your group are residents?
The Gambles are the only actual residents.
Okay, so this is mostly small businesses who are resisting this.
There's 3 small businesses, 1 rental property, residential rental property owner, and 1 actual resident.
Brad, if this gets into an appeals situation, I guess we'd go to the appeals court and then go to the Supreme Court, potentially, the state Supreme Court. How long a process are we talking about?
It could take months. If it goes to the Supreme Court, it could take a couple of years. So
we're talking about a long time.
It could take a long time.
When you teach, and we only have about a minute left, when you teach the issue of eminent domain in a property class, or whatever class this really comes up at law school, what is it that you try to drive home to your students?
That the whole issue of what's public use and when it's fair for the government to take land has remained controversial, especially when they're taking the land and they're turning it over to a private developer. If they're taking the land for a highway or a state building or a city building, it's less controversial. But if they're taking the land and then turning over a good part of it to a private developer, there's a lot of controversy whether that's right or not.
And do you have a personal feeling about that? I mean, I've just asked you to sort of lay out the case up to this point. But as a lawyer, do you have personal feeling about that?
I think in some cases cities couldn't redevelop property unless they took some by eminent domain, because you do have the problem that a few people might not want to sell, and then they couldn't put together these big projects without using eminent domain. On the other hand, it can be unfair, particularly to residents who don't want to, somebody lives in their home for 30 years and doesn't want to leave. So it's a tough issue. I think it's justified. If the area is truly blighted, it's justified.
So a true lawyerly position, you could defend either side of this.
Yes, I could.
Okay. Well, we're going to be watching this, and I guess the decision from the trial court is going to come maybe in a week or 10 days. Is that what's expected?
I would imagine 2-3 weeks.
2 or 3 weeks.
Yes.
Okay. Thank you for being here this morning.
Thank you very much.
Very
Thanks,
good.
man.
Stay tuned. Last year, the fate of Terry Schiavo, a woman who has lingered in a vegetative state for 10 years, gripped the nation. When we return, a discussion of the recent Vatican statement about the care of people in a vegetative state. Welcome back. On March 20th, Pope John Paul II spoke at the conclusion of a Vatican conference entitled Life-Sustaining Treatments in the Vegetative State, Scientific Advances and Ethical Dilemmas. He said the administration of water and food, even when provided by artificial means, always represents a natural means of preserving life, not a medical act. In other words, what had been understood as extraordinary and therefore possible to refuse should now be seen as obligatory care. Some medical ethicists have reacted that this statement contradicts long-held Catholic positions and poses real challenges for Catholic doctors and hospitals. I am joined now by 2 people to discuss the implications of this pronouncement. Jack Gallagher is the Corporate Director, Ethics for Catholic Healthcare Partners. CHP is one of the largest not-for-profit healthcare systems in the United States and the largest in Ohio. The system consists of more than 100 corporations serving the health needs of people in Indiana, Kentucky, Ohio, Pennsylvania, and Tennessee. Dr. Terry Rowland is the chair of the ethics committee for the Westside Mercy Franciscan hospitals, including Mount Airy, St. Francis, St. George. Welcome to Newsmakers. Terry, did I get your last name right?
That's correct. Thank you.
Okay. Let's begin, Jack. Does the Pope's statement on March 20th represent, in your mind, a shift in position?
I think it represents a clarification and a development of what he had written earlier in an encyclical called The Gospel of Life. I think when you look at the Pope's remarks for March 20th, we need to keep in mind that they are focused exclusively on patients in a permanent vegetative state. His remarks do not have any significance or meaning for palliative care, hospice care, end-of-life care, for people dying of chronic disease or dying at the end of life.
So this would not affect hospice care?
Not in any way whatsoever. Well, in fact, a person in a persistent vegetative state or permanent vegetative state would not be in a hospice setting, most likely. They'd be in a long-term care setting, long-term care hospital.
Okay. So given that, in the hospitals that you deal with, which are more acute care hospitals, does this have any implications?
It could, in the sense that patients could prospectively end up in a persistent vegetative state.
So the question about when to start care.
Right, and when to make that diagnosis. It's not always an easy diagnosis to make, and particularly early on, you do not know what the course of that patient's mental condition is going to be. So it's not likely to be a diagnosis that's going to be made in the acute care setting.
In a hospital like yours, you're the chair of the ethics committee, as I understand. What does the ethics committee do? And you're the ethicist for a system. I'm not sure that most of us know about this sort of thing. Is it that you set policy in broad terms, or do you actually, in a hospital setting, do you get into individual cases helping doctors make decisions?
We do some of each. We review policies and general guidelines. Many times there are more guidelines than there are policies in terms of how to deal with many times end-of-life issues, but any other issue that comes up that has ethical and moral implications. But we also deal with individual cases. We act as consultants on cases when asked, and anyone can request an ethics committee consult within the hospital, the patient's family, the physicians, nurses, anybody. And it should be emphasized that our committees are not decision-making committees, they are consulting committees. We merely act as facilitators to help discuss the moral and ethical issues, and really to help families understand both the medical issues and the ethical issues.
In your case, you're the ethicist for a system. Within your system, and that's one of the reasons I wanted to describe the system a little bit, it's described as over 100 corporations are part. Do you have some facilities where people in vegetative states would be cared for?
I think the answer to that is no, in terms of maintaining them over a long period of time. I think when we are likely to see these patients is that patients who are on artificial nutrition and hydration for a long period of time are going to develop a series of complications. And aspiration pneumonia would probably be the most common. There are also infections, and I'm sure Terry could list other complications these patients will experience. At that point, they're likely to be transferred to acute care hospital for their treatment. And in the course of that treatment, some of these questions may come up.
Okay, so you would see these patients, but not necessarily on a day-by-day basis.
That's right.
It's when their other complications have arisen. Working in Catholic institutions, and Jack, I know you're Roman Catholic by background, Terry, I just don't know. Does this pronouncement pose any difficulties for you? Is this troubled you, or is this just, we're going to incorporate this and move on?
I think there's a couple things that need to be said, and I think one is to get the broad picture and then come down to the individual cases. It's clear that where all this is coming from the Holy Father's perspective, is that we need to become more sensitive to the inherent value of human life and the personal dignity that adheres to each of us as human beings in this world. And throughout his writings, that has been thematic, the value of human life and the inherent dignity of each person. Secondly, over the last couple of years, he's become very focused on the disabled. And we have had a whole series of cases in the United States because of the level of our healthcare system, in which we have raised questions of whether or not a significantly disabled person's life should be prolonged through what might be deemed extraordinary means of prolonging that life. I think the classic cases, to go back to the Reagan administration, were the baby Doe cases. If you have a child who's born with some form of Down syndrome, and the same child also has some sort of obstruction in their digestive tract, that child is perfectly capable of living if we remove the obstruction. But should the parents be required, and should the parents make a decision to go ahead and have that removed? And that was a very controversial issue. And I think what the Holy Father is calling us to is to see that these children do have real value to us, and the fact that they have this bowel obstruction should not be an impediment to their being able to live the level of life that they're capable of attaining. And I think when you look at that sort of approach to, we need to be very careful in thinking about how we withhold and when we withhold life-prolonging means, particularly with regard to the disabled. And I think the Holy Father sees these patients in a permanent vegetative state. That's a patient who has been in this condition for more than a year. It's persistent for a year, it's permanent after a year. And that's a medical terminology. He sees them as disabled.
The case I thought of immediately, a little more recent, is the Terry Schiavo case in Florida. Now, there is a person who fits the definition, am I correct?
Yes.
Yes.
And how do you think, what does this say about her case?
Well, obviously there's been a tremendous controversy within the family and within the community about that particular case. I think that it weighs in on the value of continuing to give nutrition and food from the moral and ethical standpoint.
In effect, does it support what the Florida legislature and governor then did and made it a legal requirement to sustain hydration and nutrition for her?
I would think so. I mean, I personally hesitate to see the legislatures having to weigh in on these issues because.
But isn't that exactly what worries a lot of people? Yeah. That this a statement from the Pope, and you move from that to positive efforts to try to affect legislation that not only impact Catholics but impact a broad range of people.
If I could maybe add two dimensions to that. One is that there has been an ongoing controversy among Catholic moral theologians, Catholic ethicists, in terms of when you look at patients in a persistent vegetative state or a permanent vegetative state, is it simply life that needs to be prolonged? Any facsimile to the underlying biological processes, is that what we are to respect? Or are we to look at what enables us to enjoy human life, to interact with one another, and do all the things that make human life really valuable to us? And there's been one group of people saying vitalism is enough as long as there's some form of life there, it's human life, and it should be protected. Another group of theologians saying that you need to have the capacity for human interaction and human fulfillment at some level. The other side, the second point that I think is worth thinking about, is that part of what the Pope is saying here is that we have societal responsibilities to these disabled people, or to people in a persistent or permanent vegetative state, and that when the issues become that the family can no longer bear it, he's saying we as a society, we as a community have obligations.
We have only about 20 seconds left, so I'm basically out of time. Very quickly, do you have any sense that this may then move on to saying something like a do not resuscitate order isn't credible?
No, I think it's focused only on patients in a permanent vegetative state.
Thank you very much. These are complicated issues and hard to deal with in 12 minutes, but I appreciate your throwing some light on this and being here this morning. And thank you for making Local 12 Newsmakers a part of your Sunday morning. Join us again next week to meet the women and the men shaping our community for the future. Have a good week.